Hello everyone, I'm Dhriti Dhere and welcome to the lecture 2 of CrPC. And in this lecture, we would be covering constitution of criminal courts, offices and their powers. So let's start off with today's topic. So before that, let's remember this that when now we remember that what was the need of CrPC, we saw the uses of the code that because it affects human values so much, etc. So we first need to understand what are the main mechanisms or what are the major players that are involved in a criminal trial or such. So we will see that obviously there first needs to be a court. So if there's a court, then obviously there needs to be some kinds of a counsel, one side for the accused, for the prosecution. There must be two counsels also. Then who will do the invest? Somebody has to give you information, some kind of somebody has to go behind and find the details, etc. So that part will be being done by the police. And then whatever punishment I'm awarding, as you know, in criminal procedure, criminal laws, you will see that in contrast to civil laws, here in criminal laws, you are punishing a person rather than taking compensation, etc. Like you're putting under imprisonment or giving death penalty or other such things. So somebody must be there to execute that part also. So you also see the prison authority. So in general, when we are dealing with the different organs that are taking part in a criminal trial, we see the court, we see the counsels, the public prosecutor, the counsel for the victim, etc., and the counsel for the defense. Then we see the police playing an important role, then also the prison, correctional services and other such important players. In today's class, we'll see that what is the code talking about in respect of the courts. So the first thing that we see here is section 6. Section 6 is telling us about the classes of criminal courts. You see that it is telling you that, okay, you know, in one state there is an high court and there may be a lot many courts, etc. But for the purpose of CrPC, you have the next, you have the sessions court, then you have the judicial magistrate of the first class or a metropolitan magistrate, then you have a judicial magistrate of second class and an executive magistrate. You need to remember that an executive magistrate is different from a judicial magistrate, and both of them perform very different functions. So section 6 is telling you about the classes of criminal courts that are there. There is a high court, sessions, judicial magistrate class 1 or a metropolitan magistrate, judicial magistrate class 2 and the executive magistrates. Let's try and go deep dive into it. So what are courts of sessions? First, we need to understand what is sessions in itself. So sessions division that is there is comprised of either one district or a number of districts. So a sessions division will be established by the state government in consultation with the High Court, and they in consultation we can also alter the limits of a sessions division or divide it. Like if they find that in a previous time one particular sessions division was made, that okay, this particular area will have one this particular area comprising of 5 districts comprises of one sessions division. Now with the passage of time, you saw the population growing over there, the number of grievances of people, the cases being lodged getting higher and higher day by day, then obviously one sessions court was not able to handle the upcoming load that was coming of criminal cases. So the court can now decide, okay, we will now establish, the state government and the high court in consultation, they let's realize that okay, let's now limit its this particular sessions division to only 3 districts, and the rest of the 2 districts we can make a separate sessions division. Okay, that is how you're seeing, and this is there in section 7. Now what is section 9 saying now? Now that you have a sessions division, you have a sessions court. Now who is presiding that? It will have a presided by a sessions judge, and he's appointed by whom? He's appointed by the High Court. Then the High Court can also appoint additional and assistant sessions judge. And sessions judge, there is no restriction that just because you are a sessions judge for one particular district, you cannot be for another. It depends. You can be appointed for another sessions division also, and this appointment is done by the High Court. Here I want to remember the difference between additional and assistant. Additional means almost on the same rank of the like sessions judge and additional sessions judge. Both are sort of taken as par, but if the word assistant is used instead of additional, you have to assume that it is an inferior grade than the sessions judge. So a sessions judge, assistant sessions judge is inferior to the rank of a sessions judge. However, an additional sessions judge is not inferior to the rank of the district judge. They have similar powers, but in case of administrative control and all of that, he will obviously, the principal sessions judge will have more power. Now what we'll see there now, because we're dealing with who is presiding this office, so there may be situations where that office may fall vacant. So, and there may be a case that is come for urgent disposal. It requires urgent disposal. You cannot wait for the normal procedure for somebody to get promoted or get appointed, etc. In those cases, High Court may say that, okay, first they'll see that if there is an additional sessions judge available, then they'll ask him to dispose of that case in the same capacity as that of the sessions judge. If no additional sessions judge is there, then that matter will be passed on to the assistant sessions judge. If he is also not there, then to the chief judicial magistrate. So for that particular urgent application disposal, they are exercising the powers of the sessions judge. Now what we have to see, now where will this particular judge sit? Now sitting will be there, whatever specified place has been given, that this is the sessions division has been established, the sessions court is here, so the sessions judge will sit there, so they can sit there. But however, whenever the court is of opinion that for a particular case and general convenience of the parties and witness, etc., they'll take consent of both the parties and decide that, okay, for disposal of this particular case or only for examination of a particular witness, etc., the sessions court will be sitting in another place. This can also be done. Then, as I had already said, assistant sessions judge is subordinate to the sessions judge. And what is the main distinction that you can see between the sessions judge and the additional one is that the sessions judge is deciding how the business will be distributed amongst all the assistant sessions judges, etc. And the sessions judge may also make provisions that if I am absent, if I am unable to act, then who will take my place and perform that substance. Here also remember, first preference will be to an additional sessions judge, then assistant, and if not, then to the CJM. This is given under section 10. So this was all about the courts of sessions, where we saw section 7, 9 and 10. Now let's see the courts of a magistrate. We remember in 6 we had seen High Court ke baad we had the sessions court coming, and then we saw the magistrates court, the judicial magistrates class 1, judicial magistrates class 2. Now section 11 is saying that in every district which is not a metropolitan area. What is a metropolitan area and all of that we'll deal a little later, just be patient for that. Let's see this. For every district which is not a metropolitan area, state government can consult with the High Court and can establish as many number of courts of JM1 or JM2. I have put it in short form. It means judicial magistrate class 1 or judicial magistrate class 2. So there is no particular limit that has been given. It is depending on the state government and the High Court what they feel is necessary for a particular district. Now for a special case or case, there can be a special establishment of a court of judicial magistrate class 1 or 2, and if it has been established and whoever has been given that power, only that person will be dealing with that special case or cases and no other else. And who appoints the presiding officer of such courts? He is also appointed by the High Court. And a judge in a civil court, a civil judge can also be conferred the powers of a judicial magistrate class 1 or a class 2 if the High Court feels expedient in the interest of justice, etc. It is required to do so. So what are you saying? Every district there will be number of judicial magistrates 1 or judicial magistrates class 2. Special cases somebody can be appointed, presiding officers by the High Court. A civil judge can also be given the same powers of JM1 or JM2 if the High Court feels so. Now next what do we see? That in section 12 is saying now who will be, now we have made so many courts, somebody needs to preside there, somebody needs to have a little higher control than the rest. So what the High Court will do in every district which is not a metropolitan area, High Court will appoint a judicial magistrate class 1 as a chief judicial magistrate, and some other judicial magistrates class 1 can be appointed as additional chief judicial magistrates, or some powers of the chief judicial magistrates or all of the powers can be conferred to that person. And the High Court can also do that for a subdivision in a district. If there are subdivisions, for a particular subdivision, one particular judicial magistrate class 1 can be made the subdivisional judicial magistrate, and he will be given certain responsibilities, and this subdivisional judicial magistrate is subject to the general control of the chief judicial magistrate, but he'll have powers of supervision and control over all the other magistrates except the additional chief judicial magistrates in whichever subdivision he is being appointed, and the High Court will specify what all powers he has. And section 14 is saying that the chief judicial magistrate will always be subject to the control of the High Court, and the chief judicial magistrate is the one who will define that which local areas will come under which magistrate and how will they exercise their powers. And except if there's an exception given somewhere, wherever you have been appointed, wherever a magistrate has been appointed, then his powers will extend throughout that particular district. And what is section 15 saying? That a sessions judge is always superior to a chief judicial magistrate. That is, a chief judicial magistrate is always subordinate to a sessions judge, and every other magistrate is subordinate to a chief judicial magistrate, and the chief judicial magistrate is distributing the business amongst them. However, the general control of the sessions judge will always be there. And what is section 13 saying? Section 13 is talking about a special judicial magistrate. So a high court, if it has been requested by either the state government or the central government, can confer upon any person who has held any post under the government all or any of the powers of either judicial magistrate class 1 or class 2 for a particular case or a particular class of cases in any local area which is not a metropolitan area. However, this such person who has to be appointed should have the requisite qualifications or experience in relation to legal affairs as the High Court may decide. And what are they called? They are called special judicial magistrates. What is their term? It is a term of 1 year by a general or a special order of the High Court. And what can a High Court do? They can also empower a special judicial magistrate with the powers of a metropolitan magistrate in relation to any metropolitan area. So what we have seen here in the magistrates part, we have seen that every district, that obviously you have seen that they can be judicial magistrate 1 and 2 courts, then who will appoint the presiding officers. 12 you saw about the chief judicial magistrate, additional chief judicial magistrate. Then you also saw about the subdivisional judicial magistrate, that 1 JM1 can be appointed as such. And obviously the subdivisional judicial magistrate will be subject to the general control of this CJM, and he will not have, obviously he will not have powers of supervision and control over an additional CJM. And then CJM will also exercise that control in respect of which local areas will come under which particular magistrate, etc. Then a CJM is subordinate to a sessions judge. CJM is the one who is dividing the business of the court. We saw the special judicial magistrate also. So what we are seeing here is that when we saw the numbers of magistrates, in that we found the principal CJM. He is also subject to the general control of the sessions judge. He has been given a wide range of powers, that you will distribute powers, you will define the local areas in which the magistrates will work, etc. But you will be subject to the sessions judge. Then the second thing you saw about the subdivisional magistrate, he has been given quite a number of powers which are autonomous to him. He can exercise control over the magistrate, but here also he is subject to the general control and supervision of the CJM. In the same manner, the sessions also is always under the general control and supervision of the High Court. So it's sort of a hierarchical structure where somebody is looking out for each other. Somebody is ensuring that, look, even though I have given you a power, I am not leaving you to do as you wish. I'm still there to overlook in case you make a mistake. Generally, you can understand it in that way. Now the next thing, like we have been talking about so much about metropolitan area, metropolitan, etc. So what are metropolitan magistrates? So 8, 17, 18 and 19 are the relevant sections in this regard. Section 8 is telling you that what a state government can do, it can take out a notification, it will declare that a particular area in a state which has a population which exceeds 1 million will be a metropolitan area. Bombay, Calcutta, Madras, Ahmedabad are already metropolitan areas according to the code. Apart from that, any state wherever it feels the population is exceeding 1 million and it wants to do so, it will declare it a metropolitan area. State government obviously has a power to extend, reduce or alter the limits, etc. And section 7 is also saying that metropolitan areas are separate sessions divisions and district. They do not fall under a sessions division. They are a separate sessions division and a district on their own. All the other provisions in relation to metropolitan magistrates, chief metropolitan magistrates, are similar to whatever we have covered in the chief judicial magistrate and the magistratal provisions. You can go through them, then you'll understand the correlation. And section 18 over here is talking about a special magistrate, special metropolitan magistrate. You can compare it with section 30. They were honorary magistrates for a fixed period. You saw that what kind of qualifications were there, that firstly that person must have held any post under the government, and then he should also have the legal qualifications or experience in relation to legal affairs, etc. So this is for metropolitan magistrates. Then the next topic we'll see is the executive magistrates. Now I had already said in section 6 we do recognize executive magistrates as a class of a court, but they are quite different. Executive magistrates are showing you how we have implemented the separation of executive from judiciary. One line you can understand: a judicial magistrate is subject to the control of the High Court and performs a judicial role, while an executive magistrate is subject to the control of the state government and has an administrative role. However, when an executive magistrate is performing some judicial functions, then he can be taken as court, but not when he is performing his functions in an administrative capacity. And what are the relevant sections for executive magistrates? It is sections 20, 21, 22, and 23. So here what we are seeing, that in every district or a metropolitan area, as you remember, metropolitan area is an equivalent to a district. State government, what will do? It will appoint as number of executive magistrates it is wants. Out of those, one will be appointed as a district magistrate. There can also be an additional district magistrate. As I said, additional always has the same powers. And then there can also be a subdivisional magistrate. And notwithstanding all of this, a commissioner of a police can also be empowered or conferred with all or any powers of an executive magistrate. I hope this is clear. Section 21 is talking about special terms magistrate. Like we had seen section 13 and 18, where we saw the special judicial magistrates, special judicial metropolitan magistrates. Here also you have special term executive magistrates, where the state government for a fixed term is for particular area or for performing a particular function will confer all or any powers of the executive magistrate. Then what is section 22? Section 22, again here, as I said, you just because a particular authority is being given autonomous powers does not mean that it has total autonomy. It is always subject to somebody's control. So in a case of executive, in the case of a DM, where he has a power to decide the local limits of each executive magistrate, etc., he'll be subject to a state government's control. And section 23, what are you seeing? That every magistrate except the additional district magistrate is subordinate to the district magistrate, and in a subdivision all the executive magistrates are subordinate to the subdivisional magistrates, subject to the general control of the DM. I hope that is clear. Now let's move on to see what are the powers of the court. So section 26 is an important point where you need to understand which are the courts we will try the offences. For IPC, you will see that a High Court or a Sessions Court, or whichever court that has been mentioned in the first schedule, but for 376, 378 A, B, C, D, E, where you need to have a woman officer presiding the court, whatever is mentioned in the schedule will be there for a High Court or Sessions Court. For IPC, it is High Court, Sessions Court, or the court mentioned in the first schedule. Only for the 376 offences, a woman officer is needed. For any other law, whatever court is mentioned under that law, if there is not, then obviously the High Court or whatever has been mentioned in the first schedule. I hope that is clear. Then we see section 27, which is talking about the juveniles jurisdiction. So if that particular offense is not an offense punishable with death or life imprisonment, and it has been committed by whom? By a person who is less than 16 years. Who will try it? It will be tried by the CJM or any court which has been empowered under the Children's Act 1960 or any other law for treatment, training and rehabilitation of such youthful offenders. So section 30 is talking about what? Where there an imprisonment in default of fine can be given. So court of magistrate can also award such term for imprisonment where there is a default on payment of fine, provided that it's not excess of his powers which are mentioned under section 29. And secondly, if there was an imprisonment awarded as a punishment, then it should not exceed 1/4 of that particular imprisonment which he was competent to inflict. And this imprisonment in default of fine always runs apart from, like in addition to the previous imprisonment that was given, in addition to the substantive sentence that was given by the magistrate under section 29. So example, if he was punished for 6 months, then whatever for imprisonment is given for the default of payment of fine, that will run in addition to the 6 months. It does not go and merge with that 6 months. Then the next thing that we have to see is section 31, sentences in case by conviction of several offences at one trial. So in one trial, you are dealing with a number of offences where conviction is on most of them. So here you also have to read section 71 IPC, and you should read that. I have not dealt section 71 IPC here, but let's see what is written in CrPC. Each punishment will commence one after the other. So if there are 10 offenses there, you were convicted for 3. For one, you were given 6 months, 1 year, 2 years. This is the 3 punishments that you were awarded. They'll run one after the other. First, you finish the 6 months, okay, then the 1 year will go on, or the 2 year will go on, unless the court is directing that all of them will consecutively run. Just because this particular consecutive sentences and the aggregate, like for example, you will see that a particular court has power only to punish for 10 years. Okay, I'll not reveal which court. We'll go down, then we'll see which court. 10 years power only. Now he had 10 offenses he was trying. He found him guilty for 3. Now he gave him separate punishments. When you combine all of it, it is exceeding the 10-year bar that the person has, that he has a power to sentence only for 10 years. Now, this does not mean, just because this aggregate in its total is exceeding that, does not mean that he has to send the offender to trial for a higher court. However, imprisonment over here should not exceed 14 years, or the aggregate punishment should not exceed twice the amount of punishment which that court was competent to inflict. And whenever a person has to appeal from such kind of a sentence, all the sentences will be aggregated and taken as one single sentence. And then you can see sections 32 to 35. You can go through the Ware Act if you want. So this was there. Now comes a very important part, that which court can inflict which sentence. That has been dealt under sections 32 and 35. I'm sorry, that has been dealt under sections 28 and 29. So what are the first things? First, you see what is done by the High Court or the Supreme Court. They can pass any sentence authorized by law. What will the Sessions Judge and the Additional Sessions Judge do? They can pass any sentence authorized by law, except when they are passing a death sentence, it needs confirmation by the High Court. What will an Assistant Sessions Judge do? His powers are limited to imprisonment up to 10 years or and fine. What a Chief Judicial Magistrate or a Chief Metropolitan Magistrate can do, they can imprison up to 7 years or and fine. Judicial Magistrate Class 1 or a Metropolitan Magistrate, imprisonment up to 3 years or and a fine up to 10,000. Class 2 Magistrate, 1 year or an and fine up to 5,000. You need to remember this. A lot of times you might just get questions for here. So this is what we have covered in today's class. So in this particular topic that we have covered, most of the questions come from the what sentence are they authorized to, what can be the hierarchy of vote. Please remember the hierarchy of votes. A little less questions. They can ask you questions in relation to the default in payment of fine, how they can, what will happen, is it in addition to or it is consecutive, what happens if there are several offenses, who has the right to try a juvenile jurisdiction case, etc., and all of this. IPC, who is doing so, and this is what is there. So today's class will end on this note. I hope it is clear. You were able to understand how we have gone through the hierarchy of courts for the powers, who is sitting in which court, who is subject to whose control, etc. I hope it is clear. In the next class, we will be covering the offices that have been established under Chapter 2, the PPs, etc., and the Defense Counsel. All of those elements will be covering in the next lecture. I hope this is clear and there's no such error or doubts in this lecture. Let's meet in the next class then. Thank you.